147. Where two legacies are given of different dates by a parent to a child, what is the presumption? That they were intended to be identical, or that because of altered circumstances, the legacy of later date is to be substituted for the prior one, the maxim being, the presumption is against a double portion. 148. What is the presumption where the gift is to a stranger? That they were cumulative, and the stranger would take both legacies. 149. What is the doctrine of discharge by matter in payes of contracts under seal? The rule at law was that an agreement under seal could only be avoided by a like instrument and was therefore unaffected by an accord, by parole, or any other matter in payes, which would have operated as a discharge of a simple contract. In equity this is not true, as the form of the agreement is immaterial, and any act done which is a substantial discharge, will be given that effect by a decree for execution, for release, or for a cancellation of the instrument. 150. How did the equity for relief against enforcement of penalties originate? From the hardship of the common law rule that on the breach of a contract secured by penalty, the full penalty could be enforced without regard to the damage sustained. 151. Does the fact that courts of law have acquired this jurisdiction by statute, take away the equitable jurisdiction? No, the jurisdiction of equity is not ousted by a subsequent expansion of the legal remedy, unless by express words the right is taken away. 152. What is a mortgage? A security for a debt, created by conveyance of the legal ownership in property, either to the entire extent of the mortgagor's estate, or for a partial estate carved out of it, with a proviso that on payment at a specified time the conveyance shall be void, or the mortgagee shall reconvey. Adams, 110, Storiec, Sec. 1013, Fetter, 212, Bispham, 149 et Sec. Williams Real Prop. 427, 4th Kent, 160, Thornborough vs. Baker, 2 lead. Cases Ec. 1030. 153. What are the consequences that arise from this doctrine that a mortgage is a mere security for a debt? 1. That the interest of the mortgagee's personalty, Thornborough vs. Baker, 2 lead. Cases Ec. 1030. 2. Not necessary to have independent evidence or personal or collateral security of the debt. Mitchell vs. Burnham, 44 Me, 299, Chappell vs. Allen, 38 Mo. 213, Spencer vs. Spencer, 95 N. Y. 253, 3, that the payment of the mortgage divests the estate in the mortgagee. 4th Kent. 194 and cases cited. 4. That the transfer or extinguishment of the debt operates as a transfer or extinguishment of the mortgage. Sanford vs. Kane, 24 Ill. App. 504, 5, that a simple contract debt barred by the statute of limitations does not prevent a recovery on the mortgage which secures it. Thayer vs. Mann, 19 Pick, 535, Blackwell vs. Barnett, 52 Tex, 326. 6. Tender on or after the day discharges the lien of the mortgage. Tuthill vs. Morris, 81 N. Y. 94, but a tender by a stranger may be refused. Sinclair vs. Learned, 51 Michigan, 335. 7. That being a mere security for a debt, a mortgage may be given to secure future as well as present indebtedness. Klein vs. Glass, 53 Tex, 37. See also Adams, 110, and cases the cited. 154. What is the equity of redemption? A right given to the mortgagor by a court of equity under the maxim time is not of the essence of the contract in equity to compel the mortgagee to reconvey even after a forfeiture at law, on a tender of the principal debt, with the interests and costs. 155. On what is this equity based? On the fact that the real transaction was a loan on security, and that the forfeiture by non-payment is a mere penalty which may be relieved against on subsequent satisfaction of the debt. 156. How is this equity of redemption enforced? By a bill filed praying for account and redemption, and insisting on a reconveyance with a tender of the principal and interest due, and all costs, either in equity or at law, which have been properly incurred by the mortgagee in defending his right. 157. What is the difference between a conditional sale and a mortgage? A conditional sale is one made with a power of repurchase at a given time, and on failure there is no equity to redeem, while a mortgage is a conveyance of the legal title with a defeasance deed or clause, and a right to redeem even after the day passed. 158. What are the maxims of equity governing conditional sales and mortgages? Once a mortgage, always a mortgage. Equity regards substance rather than form. And under these two maxims, even though a sale be made which is in form conditional, if it appears to the court that it was in reality a security for a debt, it will be treated as a mortgage. 159. How may the equity of redemption be transferred? It is subject to the ordinary rules, passing by the same means of devolution, may be devised, settled, or conveyed or transferred by mere right to enjoyment. Adams, 113, Fetter, 219, Bispham, 151, 8 sec. 160. If a mortgagee transfer his interest, what effect does it have? The parties who take the estate are bound by the same equity as himself, but if there has been an escheat, it is doubtful if the equity of redemption will stand as against the person taking under the escheat. 161. If a mortgagee be dissatisfied with the security for his debt, what action may he take? A suit at law to enforce payment, or take possession of the mortgaged estate, or he may file a bill to foreclose, or pursue both of these remedies at the same time. 162. What is a foreclosure, and how many kinds are there? A foreclosure is the right which the mortgagee has on default by the mortgagor to file a bill in equity to prevent the mortgagor from afterwards making any claim of right to the mortgaged premises. There are two kinds, the strict foreclosure, and the general foreclosure. 163. What is a strict foreclosure? One where, on a bill filed to exclude the mortgagor, a decree is made giving the mortgagee the possession of the property as a satisfaction for his debt. 164. What is a general foreclosure? One where on a bill filed to exclude the mortgagor, the court decrees the property shall be sold, the principal, interest, and costs paid, and the balance, if any, returned to the mortgagor. The general foreclosure is perhaps the only method used in this country, except where the mortgage carries with it a power of sale, when no foreclosure proceedings are necessary. 165. A mortgagor becomes bankrupt. What is the right of the mortgagee as to foreclosure? He must elect between two courses, either relinquish his security and prove the whole debt in a bankruptcy court, or realize upon his security, and afterward prove for such part of the debt as was not satisfied by the foreclosure. In other words, he loses general creditor and at the same time retaining the right to foreclose. He cannot have both. 166. Name the imperfect securities. 1. Mortgages of a trust or equity of redemption, and equitable mortgages by imperfect conveyances or contracts to convey. 2. Equitable mortgages by deposit of title deeds without written contract. 3. Welsh mortgages. 4. Trust deeds in the nature of mortgages. 5. The equitable lien of a vendor or purchaser of real estate. 6. Equitable fieri faces and elegit. 7. Judgment charges under statutes of Victoria. 167. What is the peculiarity of a Welsh mortgage? That no time of payment is specified, so that the mortgagor is entitled to repay the debt with interest at any time, and the mortgagee is not entitled to foreclose. 168. What is an equitable lien? This lien is sometimes called the vendor's lien, and differs particularly from a common law lien in that it relates only to things real and operates only after the possession has been claimed, and that possession is not essential to its validity. 169. Define a common law lien. The right one has to retain a personal chattel until the debt due the person retaining is satisfied, and common law liens arise in three cases independent of agreement or use wage. 1. Where the lien is held by reason of labor or expense in improving or altering the chattel. 2. Where by law the person is bound to receive the chattel or perform the service for which the lien is claimed. 3. Claim for salvage. Possession is essential to the validity of the lien. 170. How many classes of liens are there? 5. 1. Common law lien. 2. Equitable liens. 3. Statutory liens. 4. Liens by agreement or contract. 5. Liens by usage. 171. Give an example of an equitable lien in favor of the vendor. X conveys property to Y. Before receiving the purchase price, the lien or charge arises in his favor immediately on the delivery of the conveyance. As to the vendee, if he has paid the purchase price before the conveyance made, then the lien attaches in his favor. 172. What are writs of fiery faces and elegit? They are writs of execution after judgment requiring the sheriff to levy the debt out of the debtor's personal or real estate respectively, and issued out of a common law court. An equity of redemption or trust is exempt from execution at law, but an exception to this rule was made by the Statute of Frauds, 29 Chas. 2. Where the trust was in favor of the debtor at the time of execution. This exception gave rise to the equitable fiery faces or elegit. 173. What is the doctrine of conversion? That where money is directed to be invested in land or land sold for money, either by a mandatory trust or by a binding contract at law, it is regarded in equity as an accomplished fact, although the change has not actually been made. 174. Under what maxim does the doctrine of conversion arise? Equity regards that as done which ought to be done. 175. What is reconversion? The returning or changing back to its original character of the thing which was the subject of conversion. 176. What is the rule of conversion with respect to trusts? That where an imperative trust is created, directing money to be used in the purchase of land, or for the sale of land for money, that equity will regard the act directed to be done just as though it was de facto done, during the continuance of the trust and for all objects within the scope of the trust. Equitable conversion should not be confounded with the action of conversion at law. 177. What are the three requisites to constitute a conversion under a trust? 1. The trust must be imperative. 2. The duration of the conversion is coincident with the duration of the trust. 3. The conversion will operate only for those purposes which are within the scope of the trust. 178. How far does the donor's intention control the conversion? If an express intention be evidence why the donor, the conversion will only operate to the purpose indicated, and should there be illegal, or against public policy, then the conversion will not take place. 179. What effect as to the devolution and transfer of property does a conversion have? It so changes the ordinary rules applicable to the particular class of property that real estate may be distributed as though it were personalty and personalty will descend as though it were real estate. 180. What is the operation of conversion under contracts? The rule is that where a binding contract for the sale of land has been made, and is enforceable in equity, although such contract is in fact unexecuted, it is considered as though actually performed, i.e., the land becomes in equity the property of the vendee and on his death his heirs at law would be entitled, while the purchase money is considered as belonging to the vendor and would go on his death to his personal representatives. Further, the vendee would be entitled to the rents and profits of the land from the day named for the completion of the contract. 181. What are the requisites of a contract in order to constitute a conversion? 1. That the contract be binding at law. 2. That it be upon a valuable consideration. 3. That the conversion assumed be within the scope of the contract. 4. That no conversion can arise for a person who is not a party to the contract. The maxim equity regards that as done which ought to be done, applies only to persons who are entitled to enforce the contract, not to volunteers. Chetwin vs. Morgan, 31 ch. D. 596. 182. Where property has been unduly changed and is subject to a trust, what is the rule? The substituted property is bound by the same exigencies and subject to the same rules of devolution and transfer as that which it represents. 183. Who is a volunteer? One who without right or authority takes upon himself duties and obligations which in reality belong to, or should be executed by some other person. 184. If a conversion has been de facto made by a breach of trust, what are the rights of the sestuicate trust? He has his option or election to waive its restoration to its original form, or to follow it, or to have it in its altered form. 185. What are the maxims governing priorities? 1. Between equal equities priority of time will prevail. 2. Between equal equities the law will. 186. What are the statutes of fraudulent conveyances? 13th Elizabeth, c. 5. 1570. 27th Elizabeth, c. 4, 5. 1585. 187. Under these statutes in what three ways may a conveyance be rendered voidable? 1. If it be designedly fraudulent. 2. If it contain a power of revocation. 3. If it be made without valuable consideration. Adams 146. 188. What were the provisions of statute 13th Elizabeth? That all conveyances, grants, etc., of lands, hereditaments, goods or chattels had, or made of purpose to defraud creditors shall be taken, only against such persons and their representatives, as shall or might be so delayed or defrauded, to be utterly void. 189. What is necessary in order that a gift should be invalid under this statute? It must be of such property as that the creditors could resort to it for a payment of a claim. 190. In determining whether or not the equities are equal under the maxim between equal equities the law will prevail, what three rules may be given? 1. The equity under a trust or contract in rem is superior to that under a voluntary gift or under a lien by judgment. 2. The equity of a party who has been misled is superior to his who has wilfully misled him. 3. A party taking with notice of an equity, takes subject to that equity. 191. What is the principle underlying the doctrine embraced in the first rule? That the claimant under a trust or contract in rem has acquired an equity to the specific thing which binds the conscience of the original holder, but that a voluntary donee has no right of his own and acquires only that which his donor could honestly give. 192. What is the principle of the second rule? It is only a specific application of the doctrine of the law with respect to fraud, when it is fraud by representation express or implied and false within the knowledge of the person making it. Otherwise, if one knowingly misleads another into dealing with an estate, any right he might have will be postponed to the right of the party misled and until the representations are made good.